Today we are tearing into a story that exposes the rot at the core of our so-called justice system. We're talking about the Second Amendment, your fundamental rights, and a federal court that just slammed the door on justice for one American citizen. This isn't just about firearms, folks. It is about due process. It is about the right to self-defense. And it is about the blatant disregard for individual liberty by powerful institutions. We're going to dive deep into the U.S. versus Peterson case, where the Fifth Circuit Court of Appeals has not only upheld the National Firearms Act's restrictions on suppressors, yes, suppressors, but they have actively ensured that Mr. Peterson could be thrown into prison, even as his appeal heads to the Supreme Court. This is a shocking betrayal, a legal maneuver that could have terrifying implications for every gun owner in this nation. Stick with us, because by the end of this, you will see exactly how they are manipulating the law to disarm you, piece by piece. All right, let's get straight to the facts, but understand, these are not just dry legal facts. They are a direct assault on freedom. We are talking about the case of United States versus Peterson. Mr. Peterson was convicted for possessing a single solvent trap, a device that could be used as a suppressor that was not registered under the NFA. His argument? That the National Firearms Act's restrictions on suppressors violate the Second Amendment. A perfectly reasonable, constitutionally sound argument, you would think. Now, initially, a three-judge panel on the Fifth Circuit said, "Nope, suppressors are not arms. No Second Amendment protection." But then, a truly bizarre thing happened. The Trump DOJ, yes, the same DOJ under a president who often claimed to be a staunch defender of the Second Amendment, they stepped in. And for the purpose of this case, they conceded that suppressors are, in fact, protected arms under the Second Amendment. Think about that for a second. The government admitted that this item is protected by your constitutional rights. You would think, great, case closed, right? Wrong. Oh, so wrong. Despite this monumental concession, the Fifth Circuit's three-judge panel, going back to re-review the case, still ruled against Mr. Peterson. They said, even if suppressors are protected arms, the NFA's restrictions do not violate the Second Amendment because the NFA operates as a shall-issue permit scheme, and that is permissible under the Bruen decision. Now this is where it gets absolutely infuriating. Mr. Peterson, quite rightly, sought an en banc review from the full Fifth Circuit, which means all the judges on the court would hear his case. This was denied. Then, to add insult to injury, the Fifth Circuit issued a mandate allowing the lower court's decision, Mr. Peterson's conviction, to go into effect immediately. Mr. Peterson's legal team filed an unopposed motion to stay that mandate, asking the court to put a pause on it because they were going to petition the Supreme Court for review. Even the Trump DOJ at this point was fine with granting the stay. They were unopposed. But what did the Fifth Circuit do? They denied it. They said, "No, Mr. Peterson, you cannot have this stay." And here is the shocking, stomach-churning implication of that denial. Mr. Peterson could now be forced to report to prison, to serve time for a conviction he is actively appealing to the Supreme Court. His lawyers pleaded with the court, highlighting the irreparable harm he would suffer, arguing he could be deprived of his liberty for a conviction and sentence that the Supreme Court would ultimately vacate in their entirety if they rule in his favor. But the Fifth Circuit? They simply did not care. They issued an order stating, and I quote, "It is so ordered the appellant's unopposed motion to stay the issuance of the mandate pending the filing and disposition of the petition for writ assert is denied." This isn't just a legal setback. It is a profound injustice. It is a court actively putting a man's freedom at risk, forcing him into a federal prison cell, even when his ultimate appeal to the highest court in the land is pending. They are sending a chilling message. Your constitutional rights, your due process, your very freedom, can be trampled by bureaucratic fiat. This is not justice. This is a punitive, anti-Second Amendment, anti-liberty flexing of raw judicial power, and it absolutely cannot stand. Now let's take a deep breath and peel back the layers of this particular onion, because what the Fifth Circuit just did isn't just an isolated incident. It's a symptom of a much larger, more insidious problem. This isn't just about suppressors. It's about how our government, from the DOJ to the courts, twists precedent and historical context to maintain control, rather than uphold fundamental rights. First, let's talk about the National Firearms Act itself, the NFA of 1934. This was Depression-era legislation, born out of the Prohibition-era gangsterism. It was designed primarily to regulate things like machine guns and sawed-off shotguns, heavily taxed and registered. Suppressors, or silencers as they were called then, were lumped in, mostly as an afterthought. They were seen as tools for criminals, not as accessories for responsible firearm owners. The NFA effectively put these items on a Schedule I type list, much like how the DEA schedules cannabis as a Schedule I drug. No recognized medical use, high potential for abuse, severely restricted. The NFA did the same for certain firearms and accessories, heavily taxed, highly regulated, making them functionally difficult, if not impossible, for the average citizen to acquire without jumping through hoops that can take months or even years. But here is the ugly truth they won't tell you. Suppressors are not some super-secret assassin's tool. They are hearing protection. They reduce the sound signature of a firearm to protect the hearing of shooters and those around them. They are a health and safety device, a courtesy to neighbors, and in many European countries, they are unregulated and even encouraged for hunting. To treat them like a machine gun, requiring a $200 tax stamp, which, adjusted for inflation, would be closer to $5,000 today, and extensive federal registration is nothing short of an absurd infringement. Then we have the Bruen decision from the Supreme Court. This was a landmark victory for Second Amendment rights, a clear rejection of the two-step means-end scrutiny that courts had been using to gut gun rights for decades. Bruen said that when a gun law is challenged, the government must prove that the regulation is consistent with the nation's historical tradition of firearm regulation. A simple, common-sense test. If it wasn't regulated like this historically, it's probably unconstitutional. But the Fifth Circuit, in the Peterson case, brazenly twisted Bruen beyond recognition. They clung to a footnote, a minor comment by Justice Kavanaugh in a concurring opinion, not the majority opinion, about shall issue concealed carry permits. Kavanaugh suggested that licensing schemes for carrying concealed firearms may be permissible if they have objective criteria, like background checks, fingerprinting, and fees. He was talking about permits to carry, not permits to own a fundamental constitutional arm or accessory. The Fifth Circuit took this and applied it to the NFA's registration and taxation scheme for ownership of an item like a suppressor, claiming it operates as a shall-issue permit for a protected arm. This is judicial sophistry, pure and simple. It is like saying that because we have shall-issue driver's licenses, the government can therefore impose a $200 tax stamp and a 9-month wait on the purchase of a car, and you still have a right to drive. No, this is not consistent with historical tradition. This is a court grasping at straws to uphold an unconstitutional statute, all while ignoring the plain text of Bruen and the severe personal consequences for Mr. Peterson. This isn't justice. It's a bureaucratic protection racket, ensuring that the government's power to control is maintained, even when it directly contradicts your rights. It's following the rules of the system, even when the system is clearly rigged against you. So, what does this terrifying judicial overreach, this twisting of Bruen, and this cruel disregard for Mr. Peterson's freedom mean for you, for me, and for the future of our Second Amendment rights? This isn't just about a solvent trap or a suppressor in some obscure legal case. This is a dire warning about the erosion of liberty by judicial fiat, and it demands our immediate attention. If the Fifth Circuit's logic stands, that the NFA's scheme for suppressors is a permissible shall-issue regulation of a protected arm, then where does it stop? What else can the government decide is a protected arm that can be subjected to NFA-style taxes, registration, and months-long waits? Will standard capacity magazines be next? What about semi-automatic rifles, the very arms that are most commonly owned and used for self-defense? The precedent this decision sets is a slippery slope, greased by judicial activism, leading directly to a national firearm registry and de facto bans on constitutionally protected items through excessive taxation and administrative delays. This is the very essence of the corrupt system we talk about. Here you have a DOJ, under a so-called pro-gun president, admitting an item is a protected arm, yet still fighting to keep it heavily regulated. Then you have a federal appeals court that not only rubber stamps that regulation, but does so by twisting a landmark Supreme Court decision. And then, in a move of almost unimaginable cruelty, they deny a citizen a temporary stay, potentially forcing him into prison before the Supreme Court can even hear his case. This shows a profound disrespect for individual liberty and the appellate process itself. It suggests that the system is more interested in maintaining its own power and control than in upholding constitutional rights or ensuring justice. The ball is now in the Supreme Court's court, so to speak. Mr. Peterson will petition the Supreme Court for a writ of certiorari, asking them to review his case. He can also seek an emergency stay from the Supreme Court, to keep him out of prison while they consider his petition. The stakes could not be higher. If the Supreme Court refuses to hear this case, or if they uphold the Fifth Circuit's twisted logic, it will be a severe blow to the Second Amendment. It would signal that lower courts have a green light to creatively interpret away our fundamental rights. It would essentially mean that for any item the government decides to put on its NFA-style schedule, your right to own it becomes a privilege, granted only after you pay a hefty tax, submit to invasive background checks, and wait an unconscionable amount of time. This isn't about making our communities safer. It's about making our citizens less free. It's about disarming the populace. One accessory, one tax stamp, one shall issue twisted interpretation at a time. This fight, folks, is for every single one of us who believes in individual liberty and the right to self-defense. The Fifth Circuit has shown its hand. They believe they can manipulate the law to suit their agenda. Now, it's up to the Supreme Court to stand up for the Constitution and for Mr. Peterson, or we all face a future where our rights are perpetually on a timer, waiting for the next court to simply deny them. The system is rigged, they are twisting our laws, and they are actively sending people to prison just to make a point. This Peterson case is a flashing red light, a warning that our Second Amendment rights are under constant, sophisticated assault, not just from legislators, but from the very courts designed to protect us. We must expose this corruption. What do you think? Is the Fifth Circuit's interpretation of shall issue under Bruen a dangerous precedent for all Second Amendment rights, or do you believe the NFA's regulations on suppressors are justifiable? Let me know your thoughts in the comments below. Together, we will hold these institutions accountable.